Hello, hello, hello. I hope everyone's on, and that was no problem for you to hook in to see us today. I don't know what I'm saying. Good morning and welcome to the Arizona Foundation for Women's Financial Independence seminars. We're really excited that you are here today, and today's topic is creating your tax intelligent legacy, new ways to spend your retirement account. It will be presented by members of our Professional Advisors Committee, or what we call our PAC. And with this series, AFW brings you information from experts in estate and financial planning, elder law, accounting, philanthropic giving, and others who can help you make smart financial decisions that affect you, your business, your family, your community. I want to share a little bit about what we do at Arizona Foundation for Women. We advanced, excuse me, I'm sorry, I don't know what's wrong. Too much coffee. Anywho, we advance women's safety, health, and economic empowerment through research, advocacy, programs, and philanthropy. So why is that important? Because less than 2% of all philanthropic giving goes to women and girls' causes. And on top of that, a recent study ranked Arizona as the 4th worst state for women's equality. It's 18th for the gap between female and male executive pay. It's 43rd for a gap between male and female advanced degree holders. It is 47th for women's rights and 50th last for disparities between men's and women's unemployment rates. 1 in 2 single mothers in Arizona receive some form of public assistance. 1 in 2. It's really a lot higher for women of color too. So that was all prior to the pandemic. Since the pandemic, AFW has fielded numerous calls from individuals, small businesses, and other nonprofits seeking emergency funding for women. Women have been disproportionately affected by the pandemic, with many, many, many women, millions, leaving the workforce for good, a lot of them for good. And then you have the elder care and the child care that more often than not falls to women. So that is certainly the other reason they have left the working world. On top of that, most healthcare workers are female, so that they come into contact with the pandemic, which can be really catastrophic, as we know. Last year in April, right after COVID hit, the City of Phoenix Police Department saw a 140% increase in domestic violence deaths over 2019 at the same time when they're looking at those things. The quarantine and lockdown measures forced many women to stay at home with their abuser, and shelters were severely restricted. So we've adapted to the changes over time. We've never experienced anything like this last year. I'm sure everyone feels the same way, and we're tired of it. And yet still here it is, right? We're still living through it. I wanted to share with you some of the things that AFW is doing to create a more rapid response opportunities for women to survive during this time. And one of the things we've done is we've published a 2020 Status of Women in Arizona research report. It is on our website, azfw.org. Please look at it. Really important work and research that we've published. We've graduated our first class of women from our new She Leads Leadership Development Program. And I want to say that part of this program is philanthropy. And so our cohort of women, 40 women, raised $68,000 that we were able to gift out to nonprofits. Our Professional Advisors Committee hosts these financial independence seminars, which are free and open to the public. And AFW also has a new membership program where you can join other women and men in creating really a stream of revenue and resources for those organizations and women in our community. We launched a new young professionals group, and we granted out over $74,000 to nonprofits. I would like to I would like to suggest that if you have any clients or friends who would like to support women's issues and women's causes, please check out our website. We would love your support. And with that, I would like to now introduce Stephanie Bivens and Creighton Hardy. Stephanie's a certified elder law attorney in Scottsdale. She has her own practice. Actually, it's all over Phoenix, isn't it? We have 4 offices, I think. And she has 4 other attorneys. Actually, Stephanie, you can update this because I know you may have been hiring some people recently. Stephanie's a former contributing editor for Attorney at Law Magazine, Phoenix. In addition, Ms. Bivens, Stephanie, regularly speaks at community education events, serves as faculty for continuing legal education events for attorneys and fiduciaries, including the State Bar of Arizona, the Maricopa County Bar Association, Arizona Fiduciary Association, National Guardianship Association, and the National Academy of Elder Law Attorneys. And she never sleeps. Creighton Hardy will be presenting with her. Creighton's a financial advisor with Northwestern Mutual. He and his team of 4 have a combined 20 years of experience in financial services industry. And he works with a national network comprised of some of the best wealth advisors Northwestern Mutual has to offer. Creighton's team specializes in working closely with top financial professionals, closely held business owners, and executives who over the course of building wealth while working appreciates the expertise and focus they have on a few key areas: core capital preservation, tax optimization strategies, charitable gifting, and retirement distribution. That's a lot. And I'm happy to turn it over to our speakers today. Please remember to drop any questions or comments into the chat, and we will facilitate that. And I'll be back later with questions. Take it away.
Hello, everyone. So Creighton and I are going to address this, I'll say, a little casually today. We don't have any seminar materials or written materials, and we felt that that was going to allow us just to have a conversation between the 2 of us, but also with everybody that is attending. I'm going to start and just talk about retirement accounts, how you leave retirement accounts after you pass, what the recent Secure Act did for persons who are inheriting retirement accounts after the account owner passes. And these big changes in the rules have created some new planning strategies for folks. And Creighton is going to talk to everybody about what he is seeing in planning strategies, and specifically some of the things that, you know, his group and his clients are implementing. So Creighton, I'll go ahead and start off here and just describe retirement accounts and kind of what the recent change in the law was, if that works.
Sure.
Okay. So with regard to retirement accounts, we're talking about IRAs, 401ks, and generally the retirement accounts that you invest in while you're working during your lifetime that is growing income tax free. The interest and the dividends, the earnings on that account are not being subjected to your personal income tax until you make withdrawals from that account. And, you know, I've been in the law practice doing estate planning for 25 years now. Way back when I was first in practice, you didn't see a lot of folks with large retirement accounts. And that was because people worked for large corporations and they were counting on their pensions from their employers to feed their basic income needs during those retirement years. Well, as we all know, you know, there's not a lot of companies out there offering really great pension benefits and pension plans anymore. And so the government created incentives, certain tax incentives, to encourage people to retire, to save for their own retirement in the future. And that was the genesis of these retirement accounts. And we had a lot of the same laws on the books for a very long time. And then kind of almost out of the blue, mid-January of 2020, without anybody really expecting it to hit when it did, Congress enacted what's called the Secure Act. And the Secure Act is really the most sweeping change that we've seen in decades to the tax treatment of retirement accounts. And it was actually really big news for about 2 weeks, 3 weeks, until the news of a global pandemic spread. And then it got very much buried in the news cycle. So, Creighton and I are really happy to bring this information to you, because as part of your financial planning and as part of your estate planning, you need to know what these changes are and how they may impact your plan and your financial investment decisions moving forward. So pre-Secure Act, people could contribute to their 401ks, their IRAs up until age 70. And at age 70 and a half, they had to start making their annual required minimum distributions. And if they didn't pull out their required minimum distribution based on their age, some actuarial figures, there would be a penalty in addition to the income tax that had to be paid on the portion that was withdrawn. Well, what the government gives, the government can take. So when the Secure Act was implemented, they gave in the way that people can now contribute to their retirement accounts past age 70 up to age 72, and you do not have to start taking your RMDs until age 72, which is great, right? We all get a couple of extra years. We can put money into these retirement accounts, and a couple of extra years where the interest and the earnings are not going to be subjected to income taxation. But they also took, and who did they take from? Your beneficiaries, in essence. So prior to the pandemic, or not the pandemic, everything's a pandemic, right? Prior to the Secure Act being implemented, if you passed away and you had a 401k or an IRA, and you designated a human, right? A spouse, a child, a sibling, an individual, as the beneficiary to your retirement account, they could roll over that retirement account as your beneficiary after your death and stretch out their required minimum distributions based on their life expectancy. So in essence, the government isn't getting the income tax for a very long time because they're pulling a little bit out after time. Now, of course, they can make the election to pull it all out and have all the income tax paid immediately. But if they didn't need the money, chances are they would roll it over and stretch out those RMDs and get this nice growth. And people like Creighton could, invest the money wisely, and we could have a lot of growth, tax-free growth inside of these accounts. Well, that is no longer the case. So what everybody needs to understand with regard to estate planning, which is after you pass away, there are now only 5 classes of individuals. They're known as EDBs, eligible defined beneficiaries, that still qualify for what we call the life stretch. Meaning if you die and they inherit your retirement account, they can roll over and just have to pull a little bit out over time based on their actuarial life expectancy, that life stretch. And those 5 classes of people are your spouse. So just like your spouse could always do a rollover and stretch out, same thing, no income tax due when the first spouse dies, the surviving spouse rolls over that account into an inherited spousal rollover IRA. Same rules apply to spouse. A chronically ill individual beneficiary, a disabled beneficiary, a beneficiary who is within 10 years of your age. So for example, if you named a sibling as your primary beneficiary and they're just 3 years younger than you, they're within 10 years of your age, they're not more than 10 years younger than you, the other way to say that, they can still inherit and stretch. And why? Well, it makes sense. They're close enough in age, their life stretch is not going to be a whole lot different than yours, right? And then the last class of somebody who gets a little bit more of a stretch is a young person. Everybody else has to pull all of the money out that they in that inherited retirement account within 10 years of the original account owner's death. There's no planning around it. There's no loophole I have as an estate planning attorney, right? So what does that mean in the real world? Take the situation of somebody who, let's say they are 75, they've contributed into their retirement account. When they pass away, there's $500,000 sitting in their retirement account. And they were not married. And they named their 2 children 50% equal beneficiaries on their retirement account. So each child is now going to take $250,000. I can do that math in my head. $250,000 is going to be the benefit that they're going to take that they can elect to roll over. Child one has special needs and is disabled. That child can roll over and stretch out the required minimum distributions based on his or her life expectancy. So let's say that child is 35 and they have a life expectancy of 40 years till they're 75, right? They can stretch it out. They don't have to pull it all out. But the other child we'll refer to as a typical child. This child is not chronically ill or disabled. They've got to pull all the money out in 10 years. Now, under federal law, it's clear they do not have to pull out a 1/10 each year, 10% until we're done by year 10. It's clear they can wait and pull it all out in year 10. But by the end of the 10th year, it all has to be pulled out. So what Congress did is essentially escalate the amount of tax they're going to be receiving sooner, right? We are now about to have the largest transition in wealth in the US that we have ever had, because we have all of the older population, right? The 80 plus we have this huge amount of boomers moving up into the aging population. And so as people pass, we have more people with more wealth than ever before in this country. And a lot of that wealth is tied up in these retirement accounts. So Congress, with a stroke of the pen, with the Secure Act, basically just accelerated by rapid pace the amount of income tax revenue that's going to be paid to the government, or at least that is the theory. So,
well, I was just going to say, Stephanie, because it brings up a really good point, because not only does it expedite the timeline to pull those out, right? It's a larger number at the person's top tax rate, right? So
yeah.
if that example you gave of the typical child, let's say they're also single, making a $150, if you will, right? I'm pretty sure 172 is where it bumps up to that 32% federal tax rate, right? So you figure, it's 28%-ish on the 25,000 if you were to take out a tenth, and a tenth, not counting for any growth, just because I don't do math in public, but
me either, Creighton.
yeah, fair enough. So thank you for going with an easy enough number, right? But anyway, sorry, back to you. You were interrupted.
Yeah, so as a beneficiary, right, if you end up inheriting a retirement account, and many of us will be, right, just statistically, because you don't have to pull all the money out right away and have that tax hit. If you don't need the cash for some reason, you're going to roll it over. Maybe you're in your top income earning years for the next 8 years, but you're planning on retiring in 9 or 10 years. Leave the money in the account. Pull all the funds out in year 9 and 10 when you're no longer earning your income as a wage earner or a business owner, because now, without the salary or the wage income, maybe your personal income tax is going to be at a lower rate. So there's going to be some timing decisions that beneficiaries are going to make with regard to tax efficiencies, perhaps based on their personal income tax brackets, as to when and in what amounts over those 10 years they're going to pull funds out. But it's a huge change. There's some planning you can do if it's your account on the estate planning side. But there's not we can't get around the 10-year thing. But there are some interesting things that I'm seeing in my practice, and Creighton, we'll turn it over to you with regard to investing. But as far as in my practice in the estate planning world, some of the old rules still overlay to these new eligible, EDBs, eligible defined beneficiary rules, the exceptions to the 10 years. So I do a lot of special needs planning in my practice. Let's say the same situation. I have a a mom who's got 2 kids, one special needs, one typical. They're both adults. She's got roughly the same amount in retirement assets and non-retirement assets. She might choose to leave 100% of the retirement account to the disabled child and 100% of the other assets to the typical child, because the disabled child, again, can turn and stretch, can stretch that out. That might be more financially advantageous than taking the other half and having big tax losses on that. Why not? We're leveraging. The old rules also apply to when you designate a qualified charity, a 501c3 corporation or entity, a charity, as beneficiary to a retirement account. A lot of people don't know this. If you designate not a human, not an individual, but a qualified charity as the beneficiary to your retirement account, no income tax gets paid. So if you pass away and there's $500,000 in your retirement account and you leave it all to Arizona Foundation for Women, right? Or another charity close to your heart, a nonprofit, they will get all $500,000. Zero gets paid in federal income tax. So for persons who are charitably inclined, if we just have a number we want to hit, right? We want charities to receive X dollars or X percent of the estate. We're going to look first to the retirement accounts and determine, does it make sense, because we're leveraging the gift if it's going to a charity out of a retirement account. We're talking about somebody who's charitably minded anyway. We might as well leverage the gift and make the charitable donation post-death out of the retirement account, as opposed to just the typical brokerage or the net proceeds from the sale of real estate, or the individual's checking savings, kind of just general bank accounts. So there are ways we can use retirement accounts still efficiently for estate tax, estate planning purposes. One, certainly for charities. It's the first place we look to satisfy a charitable bequest because it's so nicely leveraged. Second is, do we have any eligible defined beneficiaries? It's going to be more tax efficient for those people to receive than people who don't qualify in those 5 categories. And then, we've just got, the old trust rules still overlay. Let's say you have a beneficiary and maybe they're a spendthrift, or they've had bankruptcy issues or drug or alcohol issues, and you want them to benefit from your estate, but you don't necessarily trust that if they receive the money outright, it wouldn't be wasted, or in some other way wouldn't turn out to be a negative, right? And maybe you want even the retirement account, as well as the other share assets coming from the other pieces of your investment portfolio, to go into a trust for this beneficiary. You can still designate, even with the Secure Act, a trust as the beneficiary. We ignore the trust as an entity as long as it has certain language. You have to work with the State Planning Council. I'm not going to go into the details. That's way beyond the scope of our conversation today. The trust has to have certain language, has to meet certain criteria. It's easy to make that happen. We ignore the trust as an entity, so it doesn't trigger a 5-year payout. Instead, the beneficiary of the trust, we look to them, we look to their status, and the same 10 years. Then, let's say this individual has significant creditor issues, or maybe they're just not good with money. They're a spendthrift, they're just not able to manage money, or they have special needs in some way. Somebody else is the trustee. Maybe you've named another relative or a bank or a trust company to manage the inheritance held in the trust for your particular beneficiary. The trustee can elect to pull out the money within the 10 years, but they don't have to pull it out of the retirement account and just give it to the beneficiary. They can pull it out of the retirement account and invest it in a typical brokerage account, just a non-retirement account inside of that trust. Still, we're pulling the monies out within 10 years. We're following the rules, but we don't have to distribute it and put it in the hands of the person who maybe shouldn't have it to protect it from their creditors. They're in the middle of a lawsuit or a bankruptcy or a divorce, or maybe they're just not good with money. So, there's still all that overlay. You can get the money in the way you want to your beneficiaries. You just need to know how these new rules kind of overlap with that. And everybody's situation is really different. You know, I work with families, all different situations, different types of assets, different goals, objectives. So I can't get too much into the details, or we'll be in the weeds and everybody will be asleep really quickly. But there's just a lot to know with the Secure Act and with retirement accounts in particular. And for a lot of people out there, when we talk about estate planning, much of what you have that will be going to your loved ones, whether it's a spouse or the next generation or a charity, is going to be coming from your retirement accounts. So it's important to know how that works now under the new rules. And it's really important you go back and check your beneficiary designations, and visit with an estate planning attorney familiar with these issues to make sure that not only are your documents right, but your beneficiary designations are consistent with the overall plan and mesh with your wishes. I can't tell you how many people I've met with that think the beneficiaries on their retirement accounts are one thing, and then when they look into it, they find out it wasn't updated. They never got around to doing the paperwork, or now their wishes changed and it's not consistent with their wishes. So it's always good to pull that out and double check with your advisor on, you know, who are the current beneficiaries. And if they're not the way you want, it's easy to update, work with your advisor. You get to change a beneficiary form. It's not a huge, terrible process. It's just detail work that's really important to attend to. So Creighton, I've prattled on quite a bit here about the Secure Act, kind of what it was before, what it is now, why these are, you know, impacting people and their mindset, and what they need to practically know to make sure that as they're setting up their plan for their successors, the successors are going to have, as you know, as much as possible.
Right.
But you're seeing people that are making some different investment decisions. And I know there's some new strategies that are being implemented and talked about out there in the financial planning world for people today who are making contributions to these retirement accounts. So maybe what is new?
I think just to quickly provide a little bit of context on that piece as well, the idea to, when you're thinking of a financial plan, I think every solid financial plan incorporates some sort of estate planning at the same time, right? So the decisions of how to spend down certain retirement assets, because the ability to not have to, I guess, gift those assets, or maybe it is to charities, or it's to, their beneficiaries. But I think where we look at spending dollars and what type of specific strategies do we want to accomplish and make sense of, become that much more relevant, right? So, there's a couple things that I want to touch on, and I think I can share my screen. Yeah, there it is. Stephanie, can you see this? Because I'm assuming if you can, everyone else can too.
Yes.
Okay. So when we're looking at like a spend down or a distribution strategy, we want to look at everything in buckets, so to speak, as far as how are we going to pay the least amount of tax, both today and tomorrow, quite frankly. So first and foremost, I'm going to really not talk too much about deferred annuities. We don't really utilize deferred annuities all that often, but these three, it's kind of in four buckets between the life insurance, the Roth, the traditional 401ks and IRAs, or the qualified accounts, and then the investments, which will be taxed as long-term capital gains, which is going to be lower than most folks' income tax, right? So there's also some of the guaranteed incomes that funnel into a cash reserve, and then ultimately you've got your retirement income as well. So first and foremost, what I think is important to note, right, for those of us who aren't, within 10 or 15 years of financial independence, which, by the way, as a total side note, I think I told you this, Stephanie, but I hate the word retirement, because the word retirement is just a, like the actual definition is that you're just not working anymore, which has nothing to do with your lifestyle, right? So I prefer financial independence. You can have a financial independence plan, but a retirement account, I suppose, is the way to look at it. So in like a utopian scenario for us nerds that, do the distribution planning, if we could have like a third in, investments that are taxed in the capital gains area, a third in to be taxed as ordinary income, and then a third to be tax-free. And I know later we'll talk about some of the looming tax changes that are coming down the line, but as tax rates change over time, it's sort of this foggy gray area. Nobody really has a crystal ball, but it gives us the most flexibility to optimize and really control the tax brackets as the assets become income. So, before we go into like specific investing strategies, I think it's important to lay the groundwork with some of the other buckets that you can save monies into, right? And as you were talking about, depending on the situation or the scenario, if you will, it makes sense to, it makes sense to funnel some monies or spin down maybe more monies inside of a 401k or an IRA. So I know you had touched on pensions earlier as well. So like one thing that a lot of our clients are doing with some or all of their traditional assets is they're buying an income annuity, which the word annuity, I think, has been, it's like a bad word, the A word, right? I think it's becoming a little bit more popular, but, if you think about what it actually is, it's almost like you're trading liquidity or you're trading access for income. Since, if you have typical children or what have you, it becomes a really good opportunity or an option, especially when interest rates are as low as they are, to buy income from an insurance company where you just trade assets. Hey, insurance company, here's $400,000 that, is mostly coming from this area right here that we just spent some time on. And that's just going to be income for forever, right? So that's one idea or one thing that we're implementing with clients. The second one is, speaking on the charitable side, right? When we're thinking about our clients' required minimum distributions, specifically, there's the qualified charitable deduction where you can deduct up to $100,000 per year that was gifted during a lifetime, because, as we're working with clients and we see that their balance sheet is, do I have the ability to, I guess I don't have a whiteboard, so I'm just going to unshare this screen. But if we kind of look at a balance sheet is like two parts, right? You have your life assets. If, let's say, Stephanie, we're sitting down, we're chatting, and you spend $15,000 a month. That's what you and your family spend. But maybe based on what your assets are, size of them, how they're invested, your capacity maybe is $25,000 a month. And so that extra $10,000 would be kind of the surplus. And that could be the legacy of, what you could leave behind in the end, right? Or it could be, you could spend more money if you wanted to, if you chose to.
I can spend more money, Creighton.
Fair enough. Well, and it just depends what you want to do, right? I mean, some of the funnest conversations are, because I think a lot of people don't understand what their financial capacity truly is, especially first generation wealth, at least from what I've seen, because they've seen what it's like to not be wealthy. They're the first generation, right? And they don't necessarily want to go back. And so they they live a very conservative lifestyle sometimes, which isn't a bad thing. So, I mean, that's generally what got them there in the first place. But where I'm going with this is with that legacy piece, right? Some people want to actually see the impact that the dollars they give has on the organizations or the people or the family members. You know, it was a few weeks ago, but we had a client who, it was really neat to see that they'd been talking for the last few years, and then with COVID about, taking their whole family on this $30,000 vacation to Hawaii, and they were kind of going back and forth on it. And I think having that understanding is just relevant and important. But, speaking about legacy during a lifetime, the qualified charitable donation, tax deduction, where you can just give that to a charity directly, is another thing that we're seeing a lot of times. And then lastly, while they're, as you kind of alluded to, when the income starts to drop off, right? What we'll do in the first few years, depending on how their situation set up, because that utopian scenario I described, as you've already alluded to, most people have their wealth and the equity in their home and their retirement accounts, right? So it's, we can make some shifts and changes, but you can do in today's law what's called a Roth conversion, where you basically take money from one pocket, put it into another pocket. It's another pair of pants. You pay income tax on those dollars today. And it helps, alleviate some things. Another, to kind of fall in that same line. Am I just rambling too much right now, by the way? But I feel like this is a very one-sided conversation.
I have clients that are actively now, because you can pull money out of a traditional IRA or a 401k when the older generation is pulling it out, and let's say they're retired and all their income is just, there's no wage income. It's just their Social Security and their interest and dividends. They're going to be in a much lower income tax bracket than the kids. And so what they're doing is they're pulling out money from their traditional IRA 401k, paying the income tax at their rate, and funding that into the Roth IRA, because later, if they don't use the Roth IRA funds and they pass away, it will go to the kids and the tax has already been paid. Right. And so you're leveraging ultimately those dollars to the children or to whomever the beneficiary is, without, but you can still use your money. You can still pull it out of the Roth if you need it. So I think that's what you're getting at with that planning strategy. Yeah. I'm seeing clients do that. And there's been chatter for the audience. There has been chatter, and I'm sure Creighton will talk about this, about Congress ending that, about not allowing you to move money into a Roth that came directly from another taxable account. Yeah.
Hi, this is Jennifer. I just want to chime in that I'm really glad you explained that, because I couldn't quite get to why, if they have to pay taxes on it. So the idea is they take it out when they're in a low income tax bracket.
Correct.
Got it.
Right. Because they're thinking they're not going to need it themselves. And so they'll pull it out of something that when it goes to the kids will be taxed at a presumably higher personal income tax rate to the kids, and get it taxed at their rate and throw it into the Roth. Yeah. Right. Which is still allowed for now.
Yeah, that's one reason. And then another reason that we'll see, just large expenses come up, right? Yeah. So to have pockets of tax-free money, so you don't start pushing everything over your top income tax rate, becomes really relevant. It's all situational, but I think if anything, as we're talking about a lot of these changes, Stephanie, I would say we could probably agree that the financial plan that'll win most of the time is the one with the most options, right?
Yeah.
Or the estate plan as well. And then another thing that we'll look at doing too, depending on, this is going to be more relevant with like larger IRA balances. If, let's say, the tax on, depending on what the tax would be to convert things over to the Roth, which we could do smaller conversions over time, but if there's pension incomes or other things that would push the ordinary income tax up fairly dramatically. One option too, and it's a unique scenario, is we'll get a life insurance policy on each spouse. And the idea with the life insurance policy is when one spouse dies, that's the last year that they pay taxes married filing jointly. Life insurance, as long as it's not above the estate tax limitation, if it's owned by a trust. Anyway, that's, another piece, but life insurance proceeds are never taxable. So they always pay out tax-free as a death benefit. The idea there is we can use that to pay taxes on a full IRA
Conversion.
So then everything is tax-free thereafter. It also helps with some of the legacy planning as well. Now, Stephanie, you kind of gave the preview, if you will, to the movie, but there is some chatter happening. I know it was appearing for the Build Back Better initiative that's going to be voted on in Congress later this month, but there is potential that Roth conversions may no longer be allowed after January 1st of 2032, which I think becomes really relevant to start making moves and shifts while you can, to be fair, and making sure that, you're working with, a team of advisors on different fronts that are really able to tackle some of this, situation, or you just have a lot of spare time because you're financially independent and you're not working and you want to research some of this stuff. That's always an option too, but I would advise against it. Granted, I can't advise on anyone's one situation. There's my disclosure, but so that's one change. And then I'm curious too, Stephanie, because thinking about some of the looming changes, right? One looming change that we know is going to happen, particularly with estates, which, and I think right now, if you want to touch on the specific, I believe it's 23.75 million for a couple is the estate.
Yeah.
And so if
I was going to talk about that. So
please do.
Right. Yeah. So right now, when we talk about estate tax, we have under the current law what's called a unified gift and estate tax limit. So right now, each individual can die and leave to their heirs up to $11.7 million per person to their heirs. So the first $11.7 million that you leave to your kids, now you can leave an unlimited amount to your spouse. So you could be worth $1 billion, leave it all to your spouse. The government gets none of it because there's an unlimited marital deduction amount. So when we talk about the limit, it's when you're leaving monies to non-spouses and non-charities, because again, a charity, you can leave an unlimited amount to a charity that qualifies, and there's no income, there's no estate tax on that. That amount, the portion of your estate that you leave to charity gets separated out, and it's not included. That dollar amount is not included in your estate for estate tax calculation purposes. So when we talk about the limit being $11.7 million, or essentially, twice that, if you're a married couple, that's where Creighton was getting his number from. That can go to your heirs free of federal estate tax. And we are at the highest estate tax limit we've ever been in our country right now. If Congress does nothing, the estate tax limit is scheduled to sunset back down to $5 million per person by the end of 2023, which is soon, right? Couple of years. By December 31, 2023, if you die in 2024, your estate tax limit is going to be 5 million. Indexed with inflation, we think it's going to be around 6 million. With current inflation rates, who knows what that'll actually be, but it's another discussion. The Biden administration has proposed legislation to reduce the estate tax limit down to $5 million, like now. So they want to do it as quickly as they can and not wait to 2023. That's also something that Congress is still going to be wrestling its way through this year. If it doesn't get passed this year, probably next year. So Right now, we're in a really, it's a little like practicing law in quicksand. It's a little hard for me to tell clients what to expect in the way of an estate tax limit. So, a married couple that's got more than $5 million combined, but less than 11.7 right now. One spouse dies, the other spouse inherits everything. That spouse later dies and they've got less than 11.7 together. We're not worried about estate tax.
Right.
Well, same couple, let's say they're worth $8 million now. One spouse dies, the other spouse inherits everything because we didn't do any planning, and the state limits $5 million per person later. Surviving spouse dies, all 8 is included in his or her estate. Well, now we've got $3 million, nearly half of it's going to go to the federal government. So with regard, yeah, it's brutal. So with regard to estate planning right now, we're building a lot of flexibility into these plans because we don't know, particularly for married individuals, we don't know what the estate tax limit will be when the first spouse dies, let alone the second spouse, relative to the assets of the first and the second spouse. So if you're familiar with estate planning, you may hear the term AB trust, survivors, decedents trust for married couples. Couples right now who may not need to do estate tax planning in their state documents under current law, but would once it goes down to 5 million. We're building a lot of flexibility into the plans because we may just not know exactly where things are going to sit relative to the law and the assets in the year of death. So we're being really flexible. I have a number of clients right now that are making very large gifts to their children or other relatives this year. We are in a very unique window where, let's say you're a high net worth individual, you don't need all of your assets, you don't think you're possibly going to spend them all in your lifetime, and you anticipate having a large estate at your death. Well, right now we have what's called a unified gift and estate tax. And what that means is you can gift a significant amount of money now, and that reduces what you can leave to your heirs, non-spouse heirs, again, free of federal estate tax later. We're on this weird period right now where it's 11.7 now. We think it's going to go, it'll sit around 5 later, depending on what happens. So people who are above the 5, but below the 10 or even above, they're starting to give vast sums of money away. So when they do pass away, there's less in their estate, but we're in this weird gap year right now where if you give a whole lot of money and the unified credit and the estate tax limit goes down lower than even what you gave away, because you could give away more now under the tax code, the IRS has said they're not going to come back and claw back that money and reduce what you can leave later because you're giving based under the current laws. So if you are high net worth and you want to have a conversation with your advisor and your estate planning attorney, you probably needed to make an appointment a month ago, but call your advisor and your estate planning attorney because we have 6 weeks left, basically, before year end. And this has to happen prior to year end. I just got off the phone this morning with a brand new client. It's a complicated backstory, but he's sitting on about $500,000 from his father's estate that got left to him because he has a sister who has some spendthrift issues, et cetera. And he wants to set up a trust and put that $500,000 into a trust for her. Well, we can do that now. If we get it done in 6 weeks, he'll pay no gift tax and it will not impact he and his wife. So we're in this really unique time right now. We're getting close to the end of the year, so gifting is on the horizon. You better get into your advisor and think about it. But estate tax is going to be a big point of conversation because to drop it from nearly $12 million per person down to 5, a lot more people are going to need to worry about potential estate tax after their death than ever before.
And Stephanie, Jennifer here. I'm curious, why does it need to be done by the end of this year? Because the idea is that it could change as of January 1st. Oh, okay.
Yeah, that's one of the proposals, and it could go, there's been so many numbers that have been thrown around too, but I knew I had something somewhere on this darn computer, but this is just so the audience kind of knows and can see as Stephanie was alluding to, I mean, this is the highest the estate tax has ever been, dating back from 1981. We kind of saw this huge jump in 2010, kind of stuck around 5 million. It doubled, but it's already set. The law is already set to go backwards in time. I think people, I mean, just most people in general, they don't like to think about a lot of this stuff, especially when they're thinking about, I mean, death in general. It's not a very rosy thought, if you will. So I think what Stephanie's kind of mentioning is people have known that it was going to sunset backwards, since it changed in 2017. In 2026, it would go back to, the 5 million.
5 million.
Mm-hmm. But, there's the 40% tax there. And so that becomes incredibly difficult, if you will, to, plan.
Yeah, you get into situations where, there's legacy property. Maybe it's a cabin, a lake property, in a liquid asset, and it has to be sold to pay the estate tax. I mean, without proper planning, we can use insurance, you can use other tools, but, with these looming changes, again, everybody's situation is different. Now is an excellent time to get back in with your estate planning attorney, just to have a review and loop your financial advisor in on that conversation.
Right.
To say, hey, okay, is what we have makes sense, or because of the Secure Act and because of the potential estate tax and gift tax changes that are going to happen.
Well, and the capital gains tax too.
Oh yeah. Don't get me started on that one. It's all brutal.
Yeah, I think we only have
Everything
8 minutes left, so I don't know if we can go through that, but just so the audience kind of knows, the capital gains tax is set to change at the highest rate from 20% plus 3.8% for the Medicare surtax on any income over 200,000. If you have gains over $1 million or any income over $1 million, it'd be 39.6%. So I think what Stephanie's alluding to is, with some of the looming changes, the folks who tend to be most adversely affected by some of these things are those who are well planned already, because things are changing. So, and they're changing rapidly. So certainly, but it is kind of like quicksand. You're absolutely right, because
it is. I mean, you hear something different all the time. So you just have to, in my world, it's planning as best as we can for all contingencies.
Exactly.
One of the most popular trusts I've been drafting recently, really for the last year and a half, has been for a married couple. If one spouse dies, the default is everything stays in what we call the survivor's trust. And all that means is all the assets are including the surviving spouse's estate, and they can manage the trust and they have full control, and it's all still revocable. But in case the estate tax drops, depending on the assets owned in the first spouse's year of death, we want to give the surviving spouse the option to elect to fund something called the decedent's trust. And we put the deceased spouse's share of the estate into the decedent's trust, the surviving spouse's share into the surviving spouse's trust, which commonly are referred to as A and B trusts in the estate planning world. And then we keep the first spouse's unified estate tax limit and the second spouse's. So we're doubling down. We're not losing the first spouse. So in a couple, let's say that has 10 million, 5 goes into his trust if he dies first, 5 goes into her trust, the survivor's trust if she's a survivor. Later, when the surviving spouse dies, if we still have 5 million in each or below, and the estate tax limit happens to be $5 million, right? When the surviving spouse later dies, all 10 million goes to the kids free of federal estate tax. Right. Whereas if we didn't do that, all 10 is hers. She later dies, the limit is 5. We're going to have at least a 40% tax on that 5 million. And it will probably be a 45% tax if the Biden administration has their way. The relative tax rates on estate tax get more compressed and get higher under the proposal. So again, we don't know what it's going to look like. you know, there's going to be a change, if nothing else, by the end of 2023 and, you know, beginning of 2024, unless Congress does something completely different, it's going to sunset back down. So we can at least use that as a mark for potential planning. It's the best guesstimates we have until we get actual new legislation. Again, there's been a lot talked about. It's just a great time. And every 3 years, you know, where you should be sitting down with your financial advisor probably at least once a year. Creighton might want to see people more often than that, but you know, at least you need to keep good tabs on what's going on in your investments. Same thing's true for your estate plan. Maybe not every year, but every 3 years. My rule of thumb is about every 3 years. That's a really good time frame to just sit down with your estate planning attorney, look at your assets, look at your documents, compare that to the tax code, you know, what's going on, what your goals and objectives are, just to make sure that it's all still fits the overall objectives. And if anything needs to be updated, you can get it updated at that point.
Yeah. Well, I think it's so important too, because not only are the laws changing, but sometimes the situation and what's important to you today, right, is different 3 years,
Oh yeah,
a year, or 6, whatever the case is, right? So
yeah.
it's important to make sure all this stuff is coordinated, which is why Stephanie and I and everyone else in the pack have full-time jobs. But were there any questions in the chat? I know we're getting close to time here, Jen.
I asked, or we handled one of them on our end about just to let everyone know, this will be available even for those who missed it. They get a link as well and they can watch it. And I didn't have any other questions. I just chimed in when I had them, like about the Roth conversion.
Good.
And that last example you gave is a little complicated for me, but I'll ask you about it offline because I don't understand how they get all 10 million, but we're going to go back over that. I want to thank everyone for being here today. And I especially want to thank Creighton and Stephanie for just a wonderful conversation. It always gives me a lot to think about. And after one of your talks you did with us earlier in the year, Stephanie, I did go see my estate planning attorney.
Good.
And I got a beneficiary designation on my house. So thank you.
Excellent.
Thank you all both. And I hope everyone has a wonderful weekend. Please reach out if you have any questions about Arizona Foundation for Women, or if you have a client who wants to learn more about AFW and everything that we're doing for Arizona's women. Thanks again, everyone.
Oh, wait, and
Yeah.
sorry, I have one more AFW thing to just throw out there.
Yes.
I'm a member. Stephanie, I think you're a member too.
I am.
Ends member. So a really cool way that you can gift on demand. I'm all about automation over here. I'm a millennial, if you couldn't tell, but AFW has a really cool program called their membership, where you can pick a monthly donation. Can be as high as, there's not a limit on how high it can be.
Oh, no, there's no limit.
But it can be as low as like $5 or $10, something like that.
Yeah.
So build it into your budget, and perfect little plug there, but thought I would.
Yeah, no, it makes a collective impact,
Yeah,
right? You know, you might not have thousands of dollars to change the world, but if you participate with some of us who are giving 10, 20, 50, 100 a month, then it makes a huge difference.
Yeah.
Thanks, Creighton.
Yep. Just thought I'd throw that out there. So, because I know we were talking a lot about ultra high net worth, and maybe they're on here, maybe they aren't, but
yeah, I'm not, for example.
Right.
I'm a nonprofit
But you
worker.
know, to that point, it kind of doesn't, I mean, we talk about estate tax, yes, we're talking about very large sums of money, but everybody needs to pay attention to this, because if your plan isn't right, it's going to fail. And what is that going to mean? That's going to mean one of two things. Either it's going to cost more, right? Either because there wasn't proper tax planning, or because the legal documents weren't done, we have to go to court, or it's going to cost in dollars, or it's going to cost in time to get things done. So it really doesn't matter the size of your assets. you do need to look at these things, whether you have, $200 in your retirement account or 2 million. You need to understand how these rules impact your beneficiaries. You need to understand the differences in between beneficiary designations. You still, as I like to say all the time, anybody over the age of 18 needs basic estate planning documents. You don't want to become the subject of a guardianship or conservatorship because you got in a car accident. Now you can't pay your bills, because that's what's going to happen.
And
Yeah.
that's, yeah, it's so true, Stephanie. 'cause
these issues are not limited to high net worth problems, right?
No, just maybe
It's-
that
They're
estate tax.
Right.
Yeah.
and same- I
The
would say the same
basics are the
thing-
basics.
Right. I would say the same thing with the financial planning pieces too, right? Because whether it's, whatever you're spending, odds are most people don't want to decrease the lifestyle that they're comfortable at later on. And same thing for the list goes on and on.
Yeah.
Right. Right.
Listen, we're just a couple minutes over, so I do want to respect everyone's time.
Yes.
And you guys are awesome, and it was a great conversation, and we got a lot of feedback in the chat. Thanking you, and great presentation. So everyone have a wonderful weekend.
Thank you.
Right.
JC out.